Hi, we're going to look at intellectual property. Before we do, if I could ask, if you haven't already, please do take a moment to subscribe to our channel where we talk about all things tax and also look at the kind of things that you'll need to be considering if you're wanting to work for yourself or run a small business. On to intellectual property. Often you will hear this abbreviated to IP. It simply stands for intellectual property. Intellectual property refers to creations of your mind as opposed to physical and tangible property of the business, such as your machinery, your stock, your equipment. These are physical property of the business, but your branding, things that you write about, photos that you take, those kind of creations, things that are not a tangible thing that you can hold in your hand. Those are the kind of things that we're talking about. And intellectual property laws basically deal with the protection of your IP. It's important, even if you're a very small business and you're not too concerned about protecting your own IP, it's important to have a basic understanding of IP laws to make sure that you know how to protect yours, you know when it's advisable to protect yours, but also importantly to make sure that you don't infringe somebody else's IP. So, for example, to know when it's okay to use something that someone else has created, what permissions that you might need, what you need to do, rather than just using something else and inadvertently infringing somebody else's IP, which could get you into a lot of trouble and be very costly for your business. The official UK government body that's responsible for intellectual property rights is the Intellectual Property Office, known as the IPO, and they hold all of the records, all of the registrations, as well as much guidance on IP and your rights and your responsibilities in this regard. You still have rights over your IP, even without registering them. You'll have common law rights. So just because you haven't registered your brand as a trademark, for example, doesn't mean that somebody else can just do as they please with that, use your logo, etc. But registration of your IP will give you stronger protection. It is much easier then to prove that it's yours when you started using it, what you're using it for. So let's have a look then at some of the main types of protection that you should be aware of, as we talked about before, both to protect your own IP, but also to make sure that you don't infringe somebody else's. Copyright. So copyright protects your work and stops others from using it without your permission. You've probably seen this a lot on web pages, on written documents. You automatically get copyright protection. You don't need to apply for it or pay any fee. There is no register of copyright in the UK. You can, however, mark your work with the copyright symbol, as well as your name and the year that you created what you're copywriting. But whether you actually put that mark or not doesn't affect the level of protection that you have. So the things that you will automatically get copyright protection is when you create originally literary, dramatic, musical and artistic work, including illustration and photography, original non-literary written works such as software, web content and databases, sound and music recordings, film and television recordings, broadcasts, and the layout of published editions of written, dramatic and musical works. Copyright protects your work by preventing people from copying your work, distributing copies of it, whether free of charge or for sale, renting or lending copies of your work, performing, showing or playing your work in public, making an adaptation of your work, putting it on the internet. And this is obviously if they're doing these things without your permission. You are able to find much more detailed information on copyright and the copyright protections and the laws on the IPO website. So turning then to trademarks, so the IPO, on the IPO website, you are able to search for trademarks that have already been registered, and the IPO holds the register of the trademarks that have already been registered. As we talked about earlier, just because you don't register your trademark doesn't mean that you don't have protection, but you can register your trademark to protect your brand. For example, the name of your product or your service. After registration, if someone uses your brand without your permission, including counterfeiters, you will be able to take legal action against them. Once you register your trademark, you'll also be entitled to use the little R in a circle symbol next to your brand. This will show others that it's yours and warn them against using it. Just an aside, if you haven't registered your trademark, you are able to use the letters TM after your brand on your logo, just to indicate that you are using it as a trademark. But as we talked about earlier, you still have protection even if you don't do any of these things. These things just serve to strengthen the protection that you have. If you registered your trademark, you'll also be able to sell and license your brand. So again, depending on what you intend to do with your business, this may be something for you to consider. There's lots of rules on what you can and can't register, but in summary, your trademark must be unique. It can include words, sounds, logos, colours, or a combination of any of these things. And again, on the IPO website, you will be able to find much more detailed information on trademarks, and also, as I mentioned earlier, search for the trademarks that have already been registered. Turning then to patents, you can use a patent to protect your invention. It gives you the right to take legal action against anyone who makes, uses, sells, or imports it without your permission. To be able to be granted a patent, your invention must be all of the following. It must be something that can be made or used. It must be something that's new, and it must be an inventive, not simply a modification to something that already exists. It must be a new invention. Patents are expensive and quite difficult to get. So if this is something that you think is something you need to consider, then I would suggest that you take professional advice and guidance on this. There are some things that you are not able to patent, and some inventions that you can't patent include literary, dramatic, musical, or artistic works, which we talked about in the copyright section, a way of doing business, playing a game, or thinking. A method of medical treatment or diagnosis you can't patent. A discovery, scientific theory, or mathematical method. The way information is presented. Some computer programs or mobile apps you will not be able to patent. Essentially, biological processes like crossbreeding plants and plant or animal varieties, again, is something that you won't be able to patent. And as with the other types of protection and IP, you can find detailed information and guidance on the IPO website, and there will be professionals that can help you in this regard. Finally, we're going to look at designs. And again, you can search for designs that have already been registered on the IPO website. You can register the look of a product you've designed to stop people copying or stealing it. The look of your design includes the appearance, its physical shape, its configuration, and its decoration. Registering your design protects any aspect of your design, for example, both the product shape and its decoration. You will need to renew your registered design every 5 years, but registering your design does give you the right to prevent others from using it for up to 25 years. And with all types of registration for IP, it does make taking legal action against infringement and copying very much more straightforward. Once you've registered your design, you can display your registration number on your design. Some shapes of objects may already be automatically protected by design rights, but again, it's much easier to protect your IP and your design in this regard if you protect it. And as always, you can find detailed information on designs on the IPO website. From time to time, the IPO carry out events, webinars and physical events where you can learn more about IPO. And if you go onto their website and search for their events calendar, you will find out the training and the guidance that's available in respect of these events. So as we can see, intellectual property law is very complex and can be confusing. If you're not confident with what, how or when you should be protecting or can use of somebody else's work, it is advisable to take advice from an IP professional. It can be easy to inadvertently infringe another person's IP, and just because they don't take action against you, it doesn't mean that it's okay. A general rule is if you find anything that you wish to use for your own business, always contact the owner to ask permission first. Thank you for listening, and I hope this has been useful. Please do remember to subscribe to our channel so you can easily reference back to this information should you wish, and find out the other guidance that we have available to help you and support you running your small business. Thank you. Goodbye.